Question number 101. A written contract is proved as per section 91 of the Indian Evidence Act. Can the terms thereof be proved to have been altered by a contemporaneous oral agreement by a third party to the written contract? Options are: terms of written contract can never be varied. The oral agreement can be proved to vary the terms of the written contract only if the original written contract is lost or destroyed. The terms of the written contract are only binding between the parties to the documents, but a third party to the written contract can always show contemporaneous oral agreement to vary the terms of the written contract. Option 4. A third party cannot lead evidence to vary the terms of a written contract as he was not a party to the contract. Correct answer is option 3. The terms of the written contract are only binding between the parties to the document, but a third party to the written contract can always show contemporaneous oral agreement to vary the terms of the written contract. Question number 102. A is arrested and detained in custody in a case of murder. The investigation police officer within 24 hours produces the accused before a metropolitan magistrate who has no jurisdiction to try the case. Seeking police custody as investigation is not complete. The metropolitan magistrate has the power and jurisdiction to: option 1, grant police custody only for 2 days. Option 2, grant police custody for 15 days. Option 3, discharge the accused. And option 4, refuse to entertain the application as he has no jurisdiction to try the case. In this question, the correct answer is option 2, grant police custody for 15 days. Question number 103. Recording of pre-summoning evidence by the metropolitan magistrate in case of alleging cheating may be dispensed with the section 200 CRPC in which one of the following case? Option R. The complaint is made in the form of affidavit. The complaint is made by a Parda Nashin lady. The metropolitan magistrate is of the opinion that the ends of justice require so. The complaint is made by a public servant in writing and while acting in discharge of his official duty. In question number 103, correct answer is option 4. The complaint is made by a public servant in writing and while acting in discharge of his official duty. Question number 104. In which one of the following cases did the Supreme Court lay down detailed guidelines with regard to the use of section 451 CRPC, order for custody and disposal of property pending trial in certain cases? Options are: Manjeet Singh versus State of Rajasthan 2012. Option 2, Sundar Bhai Ambal Desai versus State of Gujarat 2002. Option 3, State of Bengal versus Kailash Chandar Pandey 2004. And option 4, Kailash Chandar Asthana versus State of UP. Here the correct answer is option 2, Sundar Bhai Ambalal Desai versus State of Gujarat 2002. In this case, Supreme Court laid down the detailed guidelines with regard to the use of section 451 of CRPC, which is related to the order for custody and disposal of property pending trial in cases. Question number 105. Autrefois equate principle is related to retrospective operation, double jeopardy, ex post facto loss, and self-incrimination. The correct answer for this is double jeopardy. Autrefois equate is a defendant's plea of stating that he or she has already been tried for and acquitted for the same offense. Therefore, double jeopardy is the correct match to this question. Match the two columns. Section 357 of CRPC. Correct match among the second column will be: compensation may be ordered by the court to be paid for fine or otherwise. Section 357A CRPC is related to victim compensation scheme. Section 357B CRPC is related to compensation to be addition to section 357C CRPC, the last, treatment of victims. In which of the following circumstances inquest of the dead body by the magistrate is compulsory? Murder of a child of 17 years, unnatural death of a woman within 7 years of her marriage, death of a married woman in all cases where an old man dies of cancer. Here the correct answer is unnatural death of woman within 7 years of her marriage. What is the duration of sentence of life imprisonment? Here the correct answer is option 1, imprisonment till death. Question number 109. An arrestee's right to consult and be defended by a lawyer flows from which article of the Constitution of India? Correct answer is Article 22. Article 22 talks about the protection against arrest and detention in certain cases. Question number 111. High Court's power of contempt are rooted in the provision of the Constitution of India. Article 226, Article 14, Article 21 and Article 215. Here the correct answer is Article 215. Article 215 declares every High Court to be court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Question number 112. The power to make laws vest in the Parliament and State Legislature by virtue of which provisions of the Constitution of India? Article 245, 7th schedule, Article 246, none of the above. Correct answer is Article 245. Article 245 of the Indian Constitution talks about the extent of laws made by Parliament and by the legislatures of states. It gives Parliament the power to make laws and also gives the legislative body the power to repeal them. Now let us see the question number 113. Can the High Court, while examining the constitutional validity of a statute, declare it ultra vires prospectively? Correct answer is no, it cannot declare them ultra vires prospectively. Question number 114. A High Court judge resigns from his service. An issue arises before the court with regard to the date when he demitted office. The date would be when he tenders his resignation. Option 4 is the right answer. Question number 115. Which of the following propositions of law is most appropriate? Options are: tax requires no quid pro quo. Option second, tax fee require no quid pro quo. Option 3, both tax and fee required quid pro quo. And option 4, none of the above. Correct answer is option first, tax require no quid pro quo. Meaning of quid pro quo is favor or advantage granted in return of something. Now let us see the question 116. A contract for construction of an international airport was executed between X and the central government. On behalf of X, the contract is signed by its managing director. Insofar as the central government is concerned, the contract is made in the name of Secretary, Ministry of Civil Aviation. Central government wishes to take the defense that the contract is not binding on it. Which article of the Constitution of India should it take recourse to? Here the correct answer will be Article 299. This is the correct answer because Article 299 Clause 1 talks about that all contracts made in exercise of the executive power of the Union or of a state shall be expressed to be made by the President or by the Governor of the state as the case may be, and all such contracts and all assurances of property made in the exercise of that power shall be executed on behalf of the President or the Governor by such persons and in such manner as he may be, direct or otherwise. So option third is the correct answer. Question number 117. X demits the office as the Comptroller and Auditor General of India. He has received offers for re-employment from the central and the state governments. What are his options? He can be employed by the central government but not the state government. This is wrong. He can be employed by the state government but not the central government. Wrong. He can be employed by both central and state government. This is also wrong. None of the above is the right answer. He cannot be employed by the state and the central government when he demits the office as the CAG or CAG of the Comptroller and Auditor General of India. Now let us see the question number 118. State government wishes to erect a religious structure. The cabinet explores ways and means of levying a tax for that purpose at the earliest. Can the state government enact an act? No. State government cannot enact such act. Can the state government issue an ordinance? If they cannot enact an act, they cannot also issue ordinance. Can the state government issue an administrative circular? No. Correct answer will be none of the above. Question number 190. Which of the following propositions of law is most appropriate? Right to vote is a fundamental right. Right to vote is a statutory right. Right to vote is both a fundamental and common law right. None of the above. Here the correct answer is right to vote is a statutory right. Question number 120. The word secular was included in the preamble to the Constitution of India. It was included on 3/1/1977. This is the right answer. Option 4 is the right answer. The 3 judges of the Supreme Court justices who were superseded in 1973 were: in 1973, 3 judges were superseded during the emergency era. The correct answer is Justice J.M. Sehlad, Justice A.N. Grover and Justice H.S. Hegde. This is the correct answer. Option 2 is the correct answer. Question number 122. The Constitution of India was adopted by the Constituent Assembly on, this is a very easy answer, 26 November 1949. Now let us see the question number 123. Which of the following is not a money bill? A bill which proposes for the appropriation of monies out of the Consolidated Fund of India. A bill which proposes to exempt income from the tax up to 10 lakh rupees. A bill dealing with the custody of Consolidated Fund. And option 4th, a bill which proposes to give power to Municipal Corporation of Delhi to realize extra fund by way of raising existing vehicle entry fee in Delhi from other states. In the question, it is asked which of the following is not a money bill. So option 4 is not the money bill. That is why this is not the money bill. That is why this is the correct answer. And all the other 3 options are related to money bill. Money bill is given in Article 110 of the Constitution of India. Question number 124. Which of the following is not correct in respect of Article 358 read with Article 359 of the Constitution of India? Article 358 suspends the freedoms guaranteed by Article 19, while Article 359 suspends the enforcement of fundamental rights under Part 3rd except Article 20 and Article 21. Option second. Article 358 suspends the freedoms guaranteed by Article 19, only when proclamation of emergency is on the ground of external aggression or war. Option third, Article 359 suspends enforcement of fundamental rights guaranteed by Article 19 only when the proclamation of emergency is on the ground of war and external aggression. Option 4, Article 358 only suspends freedom guaranteed by Article 19 and Article 359 does not suspend the enforcement of Article 20 and Article 21. In this question, it has been asked which of the following is not correct with respect to the Article 358 and Article 359. In the given options, option third is not correct. Article 350 to Article 360 are related to the provisions of emergency in India. Question number 125. Which of the following is not a fundamental duty as per Article 51A of the Constitution of India? To cherish and follow the noble ideals which inspired our national struggle for freedom. This is obviously the fundamental duty. To develop scientific temper, humanism and the spirit of inquiry and reform. This is also the fundamental duty. To provide for all-round development and growth of children. And option third, to safeguard public property and to abjure violence. This is also the fundamental duty. Option third is not the correct answer because it has been asked which is not a fundamental duty.